So picking up where we left off on employment discrimination, we talked about, I know, the ways that a plaintiff would prove employment discrimination and how if that employee who's been discriminated against has direct evidence of discrimination, this is loud something. Are you wearing that for opening day today? I like it. Very good. All right. It's be the first undefeated season in Major League Baseball history. All right. So if you have direct evidence of employment discrimination, you would go with that. Most of the time it's circumstantial. I think I was discriminated against in the decision that was made against me. And so therefore I'm going to say that, and then it'll be up to the employer to come up with the reason that they took the action, and then it will be up to me to disprove it, basically. That's the sort of the burden shifting framework of employment discrimination cases. Employment discrimination, broadly speaking, can take a couple of forms. One is disparate treatment. Okay, that's mostly what I've been giving you examples of so far. The individual employee was treated differently because of their membership in a protected class. If you remember from Tuesday, protected classes: race, color, national origin, gender, pregnancy, sexual orientation, age, disability, religion, if I've left any out. Not just that you are a member of one of those protected classes, but if you're regarded as being a member of a protected class, even though you may not be, that still counts. So in disparate treatment, the employee is alleging you treated me differently than other employees because you made my membership in a protected class the reason for your decision. I didn't hire you because you were Methodist. I didn't hire you because you were a man. Time out for a second, and I want you to appreciate a larger point. There is discrimination, legal discrimination, and there's illegal discrimination. We discriminate all the time. Legal discrimination takes place all the time. We don't allow children to drive school buses. That's discrimination. We don't allow people that can't see to be air traffic controllers. So we typically associate the word discrimination with having a negative connotation. And it can. Illegal discrimination should and does have a negative connotation. But I want you to realize that in decisions that we make all the time, we discriminate against people. If somebody applied for my job here at CSU and they were not a practicing attorney, they wouldn't get the job. They've been discriminated against because they're not a practicing attorney. The difference is that's not illegal, right? I'm not advocating for discrimination. I'm hoping that you will appreciate the difference between legal discrimination and illegal discrimination. Illegal discrimination has no place in our society. So back to where I was. Disparate treatment, I was treated different specifically because of my membership in a protected class. But discrimination can also happen as a result of non-discriminatory policies. It could result in discrimination to a class of people. Here's how that might work. You've all heard over time about, they've always said that the SAT and standardized testing sometimes has inherent bias against minorities. The people who write the SAT don't sit down and say, we're going to write a test that discriminates against minorities. You could look at the individual questions on a test, and we would have trouble pointing to any one of them that is in and of itself discriminatory. But if the result, statistically speaking, to a class of people is discriminatory, then that might be disparate impact. Okay? Here's how that might play out in the employment sense. I give a test, a competency test to all applicants at my factory. All right, the test itself, there's nothing discriminatory about it. You couldn't read through it and point to something that says, well, this is set up to favor men over women. But let's say that I have an applicant pool of 10,000 applicants over the years, and I've used the same test, and I have an equal number of female and male applicants. But the scoring on my test is that 80% of the males pass the test and only 20% of females pass the test. The test itself might not be on its face discriminatory, but the resulting impact is that it was discriminatory when you look at the numbers. That's disparate impact. Remember, disparate treatment is, I fired you because you're a Methodist. I didn't hire you because you're not a lawyer. Disparate treatment. Disparate impact is, we weren't doing anything overtly or purposefully discriminatory, but the result of this policy or process or whatever we're doing sure looks like it has a discriminatory impact. Kind of, whereas disparate treatment, I fired you because you're Methodist, that's more intentional. Disparate impact would be unintentional, but it still has the result is discriminatory in a way that may be illegal. As you can imagine, most of disparate impact cases involve large groups of employees, longer periods of time over which we could measure and gather statistical data that's significant. I mean, if I give a test to my applicants and I come up with this brand new test, I'm going to give it to all my 10 applicants. I got 10 female applicants. I got 10 male applicants. I got 10 non-minority. 10 applicants, 5 female, 5 male. It's the first time I've ever given this test. And it turns out that 4 of the females passed the test and none of the males did, or 2 of the males did. Are the males going to have a very good case for disparate impact? Not really. It must be hard for them to prove that a test with such a small sample size is discriminatory in its result. So disparate impact, larger classes of employees, larger classes of plaintiffs, more larger scope of statistical, geographic, temporal evidence that we might be looking at. We talked about race discrimination. We'll talk about religious discrimination for a second. Obviously, you can't make a hiring, firing, employment decision based on somebody's religion. But the law also protects members of all religions in that they are able to ask for an accommodation from their employer, a reasonable accommodation. I shouldn't leave out reasonable, that's the key word to it. A reasonable accommodation to make their religion and their employment work together. An example of that would be, I need to wear certain headgear as part of my religion. As long as that doesn't unreasonably interfere with my job. Let's say I'm a business law professor. Does it affect my job and whether or not I wear my religious headgear in here? No. That'd be a reasonable accommodation. Again, so assuming that there was a rule that said I couldn't wear headgear or something, that would be the accommodation I'd be asking for. Better example. My religion, I am a member of a non-mainstream, not Christian religion, and my religion has 5 holy days during the year. I need to be off for those holy days. Is that reasonable? Well, most traditional employers build their calendar around the Christian holiday season. You could probably pick 5 days that people are getting off for their Christianity. So 5 days for another religion doesn't seem that unreasonable. The accommodation just has to be reasonable. So before you go off inventing a religion that you're going to drop on your employer for all these holidays you need, it's got to be a sincerely held belief. So you can't just make up something. It's got to be something you could defend in court that this is a sincerely held belief. It is actually something I practice. I can show that I adhere to this. I didn't just make it up to get out of work. Discrimination based on, I shouldn't skip that part. Anytime an accommodation is requested, if it's reasonable, the employer has to grant it, unless it would result in undue hardship to the employer. All right, so there are some employer protections in there. For example, if I go to Dean Kidder and tell her that I've just converted to a new religion and I'm not allowed to speak during daylight hours. My religion prohibits that. So I'm going to need an accommodation of only classes that meet during the darkness. That's not reasonable. First of all, it's really not reasonable. But second of all, it creates an undue hardship for them. They can't all of a sudden start scheduling classes during the night when buildings are locked and students aren't even in school and it's non-traditional times. That probably violates the reasonable accommodation rule and the undue hardship rule altogether. Maybe a better example is I, at my law office, only have one employee and she needs to be off for 1 month at a time. For 1 month every year consecutive for her religion. That's an undue hardship to me. I can't be expected to operate my business without that employee for an entire month. That might be undue hardship. Maybe it's a reasonable accommodation. It's sincerely held belief that she had. It's part of her religion. It's part of who she is. It's genuine. It's legitimate. But that would create an undue hardship for me. I think undue hardship and reasonableness go hand in hand. Not always, but most of the time. Discrimination based on gender. It's not just as simple as sex, male versus female. Discrimination based on gender could be that here's a great disparate impact case. I make less money at CSU. I'm making this up because I don't know what anybody else makes. I make less money than the female professor whose office is next to me upstairs. Maybe that's just because she's been here longer, she's more qualified. There could be a lot of non-discriminatory reasons for that. But if I say that, well, let's lay out the salaries of all instructors in the business school, statistically, all the women are paid higher than the men. That might be a disparate impact. Dean Kidder is not intentionally doing that. There's no policy that says the women get paid more than men. There's no obvious intentional discrimination, but the result is that all the women make more than the men, so something is out of kilter. That is also gender discrimination. Maybe you didn't overtly make a decision to pay me less because of my gender, but it just so happens that all of the folks here get paid less based on their gender. Pregnancy discrimination is another form of gender discrimination. So that protects people from being not hired because they may be of childbearing age. Say my daughter gets married, and during the interview, the potential employer is like, I see you just got married. You got plans to start a family anytime soon? She's like, yes, we would like to, we don't have any definite plans, but that's in our future. If she's not hired because the employer is fearful that she's going to come in and end up having to miss a lot of time for maternity, or miss time because their children are sick, that's discrimination based on gender. Constructive discharge in your outline is a cause of action in employment law. It's not always because of discrimination, but it usually is. Constructive discharge happens when I didn't get fired, but basically my employer made my working conditions so miserable that any reasonable person in my position would conclude that they have to quit. They just don't have a choice. They forced me out. That's constructive discharge. I don't know if we have talked yet about, we are at sexual harassment. So sexual harassment can take a couple of different forms. One is quid pro quo. That's Latin for something for something. That's when the employer tells the employee, either you do this or this will happen. Dean Kidder says, it's time for your annual performance evaluation. I'd like to conduct it down at the Holiday Inn, if you know what I mean. Okay. If you don't meet me there for your performance evaluation, you'll be fired. Go on a date with me and I'll give you this promotion. Something for something. That is a form of sexual harassment. Another form of sexual harassment is hostile work environment. Okay? That is, I'm not asking for anything. I'm not threatening or pressuring another employee to do something, but the office environment is hostile in a sexual way. A boss comments on one of his or her employees' appearance constantly. A boss, a warehouse full of 20 men and 2 women, and all the men talk about is they treat it like a locker room. They talk about sex all the time. They make uncomfortable comments in front of the women that they think is hilarious. They tell dirty jokes. Hostile work environment. So there's a sliding scale, I would say, on that. If I'm not making light of any sexual harassment. Just trying to come up with examples that you can relate to. Maybe I work at CSU, and outside of my office, a colleague walks by and I whistle. And I do it one time. Inappropriate, sure. Uncomfortable for that employee, sure. Hostile work environment, if I do it once, I mean, maybe not, right? If I whistle every single time I see her walk by for a year, hostile work environment. Sounds a lot more like it, right? If I were to yell the worst racial epithet that there exists, and I do it one time, that might be a hostile work environment. My colleague might not have to endure that every single day for a year for it to qualify as hostile work environment. Kind of a sliding scale. The worse it is, the fewer instances or less pervasive it needs to be. The more individual it is, maybe uncoordinated or not connected, or something that in and of itself might be pretty minor, collectively over time could become pervasive. And sexual harassment. It is illegal for any employer to retaliate against an employee for making a complaint of discrimination, any kind. If I go to HR and tell them what the dean said to me, and it gets back to her, and next semester all my classes are at 8 a.m., I might feel like she's discriminating or retaliating against me for making my complaint. If she fires me, that's obviously, it's not obviously retaliation. It is a consequence that could certainly be retaliation. When it comes to hostile work environment, the examples I gave you were for sexual harassment. But hostile work environment can apply to the other protected classes as well. It's possible to have a hostile work environment based on somebody's religion. And you can imagine how that goes. It's possible to have a hostile work environment based on somebody's race, national origin, religion, age, disability. All of these other protected classes. It's certainly possible for a work environment to be so pervasively offensive and harassing that would be discrimination. The main federal law, and I'm not going to test you on which specific federal statute protects which particular class, but I do want you to know that Title VII of the Civil Rights Act of 1965 is the main anti-discrimination federal statute that we deal with. It contains the most protected classes. It was sort of a landmark anti-discrimination law, of course, obviously in the 60s, and we've built on that since then. There's been another law passed protecting age discrimination. There's been another law passed protecting pregnancy. There's been another law passed protecting disability, which we're about to get into here in a second. But Title VII was sort of the seminal statutory basis for employment discrimination. Next in your outline is age, but I think we talked about age already. Y'all remember what age you have to hit to qualify for age discrimination? 40. Good. A lot of age cases involve the burden shifting that we talked about at the beginning of class, because not many decisions are ever, well, I should probably extend that to most of all of employment discrimination. Not many times are you going to find the employer saying, I'm sorry you didn't get the job. It's because you're male, right? You get a rejection letter. We don't tolerate your religion. I'm sorry you didn't get hired. Most of the time it's going to be a situation where it's circumstantial evidence and the employer is going to give their non-discriminatory reason, and then the employee is going to have to show why that was, in fact, pretext. So disability, let's move to that now. The Americans with Disabilities Act, 1990. Not all that recent, but still pretty recent in terms of some of the other anti-discrimination statutes we have. So in order to qualify under the ADA, and the ADA, y'all, is a broad law. It's a law that talks about public buildings and access for disabled people. It's the reason that you see ramps on all public buildings. It's the reason that you see handicap stalls and restrooms in public buildings. The ADA has a very wide reach. For our purposes, in employment law, it means that a person cannot be discriminated against in employment based on their disability. And it also means that they're entitled to request accommodations in their job if they need one. Let's break that down. So, what qualifies as a disability? The ADA itself doesn't list in the statute a list of disabilities. Okay, it doesn't, there's nowhere you can go and be like, well, let me see if my disability is on the list or not. Instead, like a lot of the things we study, the statute defines what a disability is, and then it's up to the individual to take their facts and circumstances and see if that satisfies the definition of disability. There are a lot of places in the definition where we would find disagreement or where we might litigate. The ADA defines a disability in an individual as a physical or mental impairment that substantially limits one or more major life activities. That's one sentence, but if I'm the lawyer for the plaintiff, for the employee, I've got to now show that the disability or the condition that my client has constitutes a physical or mental impairment. Now, remember earlier in the semester how we talked about case law and how that sets precedent for future courts? If a client comes to me and says, I want to hire you for an employment discrimination case, I think I've been discriminated against, here's my condition. I can't go to the statute itself and find a list of conditions, but I can sure go back and look at all past cases where people have claimed disability for similar reasons and see if courts have accepted that as disability or not. So we do have some guidance from prior decisions on what constitutes a disability. Physical or mental impairment, that's one of the areas where we may disagree. What is a major life activity? That's all the statute says. It doesn't tell us what they are. Prior cases, courts have accepted whether or not something was a major life activity or not. Getting dressed, being able to feed oneself, being able to use the bathroom without help, being able to drive, major life activities. And then what substantially limits a major life activity? We could disagree about that too. There'd be plenty of litigation on that. So just that one sentence definition is packed full of areas where courts have had to really look into whether or not somebody qualified. Physical or mental impairment substantially limits one or more major life activities. You could also qualify as disabled under the ADA if you have a record of having an impairment. Let's say that I had cancer, and for a period of several years, I had to undergo treatment for it. It affected my ability to sometimes dress myself, sometimes get out of bed, just depending on the chemotherapy. But I'm in remission. So I don't currently have a physical or mental impairment that would substantially limit one or more major life activities. But I have a record of having those. If the employer makes any decisions based on my record of having that, we're not going to hire you. I mean, I know you're in remission right now, but we can't take the risk that if we hire you and then your cancer comes back, then you're going to be out a lot. Then that qualifies as a disability, a record of having an impairment. It also qualifies if you're regarded as having a disability, even if you don't have one. This came up a lot, like the best example, not the best example, but example I can give you is back when AIDS first became a thing, when it first came on the scene, the 80s, I think, I was little. But the panic around AIDS was much like we did 5 years ago with coronavirus. It was in the news every day. We made jokes about it. You don't want to be around anybody. I mean, we thought it could be transmitted. We didn't know as much as we know about today. Today, AIDS is a pretty routine thing. I mean, it's part of our culture and society and understanding now. It was brand new then. It scared people. And it mostly affected gay men. So even gay men who didn't have AIDS, if employers were looking at them as part of this overall AIDS epidemic, I don't want to hire anybody who might get AIDS or infect my workforce or anything like that. They don't actually have AIDS. They don't have a record of having it, right? So they don't qualify for a disability under those first two. But if the employer treats them as though they do, or more likely to get it, then that would be qualifying as a disability as well, being regarded as having the impairment. So the Americans with Disabilities Act would protect any employee who qualifies from being discriminated against based on that disability. It also protects employees who need accommodations in their job because of their disability. So the rules for this are that so long as the accommodation is reasonable and it doesn't create an undue hardship for the employer, then the employer is required by law to provide that accommodation. I have, let's say that my disability is that I've got a circulatory problem and it makes it hard for me to stand for more than 30 minutes at a time. I request CSU to put this chair in here for me. Is that reasonable? Sure. I mean, it doesn't affect my ability to teach the class. It doesn't create an undue hardship for them. If I had some rare disease that I'm making this up now, this doesn't exist. But I had some rare disease where I could not, the only way that I could get to my office is if I parachuted in to the top of the building. It's the only way I could enter the building. And I asked CSU if I could be allowed to just parachute in and if they would help me do that. That's maybe not reasonable. Also might create an undue hardship on them. Let's say that I had some sort of communicable disease that required CSU to build a special building for me that cost them millions of dollars. Undue hardship. not something maybe that they can reasonably expected to do. Kind of like with the religious accommodation, undue hardship and reasonableness do tend to go hand in hand somewhat. An accommodation, though, the employee does have to be able to do the job, is qualified for the job with or without the accommodation. That always was confusing to me. It was something I had to stop and think through. What that means is employees are entitled to accommodations so long as they can do the job anyway. They can already do the job. They need the accommodation to help them. But the accommodation cannot be the reason that accommodation cannot be, that's the only way they can do the job. So like, if I'm legally blind, let's say I'm an air traffic controller and I have 20/20 perfect vision, but then I get in an accident and it leaves me legally blind. So I go to my employer and say, I need an accommodation. I have a disability. We could all agree I meet the definition of disability. I need an accommodation, and the accommodation that I need is I need you to provide me with a person who can see, to sit beside me and tell me what's on the radar and basically do all that for me. I can't do the job without the person. So you don't get to have an accommodation that's the only way you can do it. You got to be qualified for the job even without the accommodation. Can I teach this class even if I had to stand up the whole time? Yeah, I can. Let me see what else we need to talk about in disability. The case that you're going to read for our discussion part of this unit, one of them is an Americans with Disabilities Act case, and it's an employee who's pretty sorry, according to the facts of the case, and he thinks he was fired because of his disability, which was diabetes, and it ended up, and he claimed that the accommodation that he needed was that he needed to be able to sleep all the time on the job. Well, you can't do your job while you're asleep. That's not an accommodation that will be reasonable. So you'll read through that for part 2. Defenses to employment discrimination. So in situations where an employee believes they were discriminated against, the employer might agree that they were discriminated against, but that there was a good reason for it. A legal reason for it, A legal reason for it. There are some legal defenses. One is bona fide occupational qualification. So that would be, I run a Catholic school. And part of our curriculum is that we teach Catholicism to our students. I'm going to require my teachers to be Catholic. So if a Methodist or a Baptist comes in, I don't hire them. Why didn't I hire them? Specifically because they're not Catholic, right? Have I discriminated against them? Absolutely. But I might have a legal defense of bona fide occupational qualification. It's necessary it's part of the qualifications for the job. I run a fancy restaurant. We have bathroom attendants. I'm only going to hire females to be the female bathroom attendants. I specifically discriminate against the males. I do not hire them for that job because they are male. That might be a bona fide occupational qualification. I design formal evening wear for women. I need to find models to walk down the runway wearing my designs. Xavier, I am not hiring you to wear my evening gowns on the runway. No offense, but it's because you're a man. That might be a bona fide occupational qualification. Business necessity. Business necessity sounds a lot like a bona fide occupational qualification, but it's a little bit different in this way. Let's say that I run a factory in the mountains of West Virginia. And I get sued for employment discrimination in a disparate impact case, saying your hiring practices, while they're facially neutral, they're not discriminatory on their face, they've resulted in you only hiring a small minority of people for this particular job class. I'm sorry, a small number of a certain minority. Well, I might say, you're right. I've got 1,000 employees in this job class, and 98% of them are non-minority. But I've got a business necessity for that because the population of 100 miles of my factory is 98% non-minority. The employee pool is such that that's all I can pull from. My hiring is actually reflective of the population of where I'm hiring out of. That might be business necessity. Seniority systems are also a good defense in employment discrimination. So typically you'll see seniority systems in larger companies, the University System of Georgia, Muskogee County School District, a hospital, unionized working environments like an auto plant, things like that. Seniority systems where written into that employer's policies is a statement that a statement of how they treat seniority in promotions and things like that. As long as the employer is adhering to seniority, a bona fide, legitimate seniority system, then that's not discriminatory. Yes, I had 20 applicants for this job, for this promotion. 19 of them were men. One of them was female. The female got the job. I get sued by some of the other 19 men. You didn't pick me. You didn't pick any of the males. You picked the one female out of 20. My defense is we operate on a seniority system here, and she had the most seniority out of all the 20 of you. I'm making my decision based on the seniority system, not based on any discriminatory reasons. Well, I would challenge that. I did discriminate, didn't I? Because I picked the person who had been there the longest. I discriminated against the 19 applicants who had less experience. So seniority systems could be a valid defense. Here's where people get in trouble. And this is where I want to talk a little bit from a practical standpoint about this to y'all. I have a client that is the state health department for the District of Georgia that includes LaGrange, Jackson, Barnesville, Newnan, that area. And they hired me about 15 years ago to give them advice on employment law decisions and things like that. So they'll call up, their HR department will call me all the time and say, hey, here's our situation. This is what we want to do. Do you see any problems from a legal standpoint on what we want to do? And it'll be something like, so-and-so is habitually late to work. We want to fire them. My advice to them is usually based in a common sense consideration. It's almost always based on whatever you do, we're going to follow the law, obviously, but we're going to be consistent in what we do. Because if we go to court and we're on the witness stand or given a deposition and we're questioned about the one decision we made, I promise you that that decision is going to be viewed in light of other decisions we've made, right? And if we're consistent about our procedures and the way that we make hiring, firing, promotion, discipline decisions, we will have a lot better chance at a good outcome in court than if we're just inconsistent, we're haphazard, we did it one way here and one way another. So like they say, we've got an opening. Let me go back to the employee who's late all the time. I would say to them, how long has this been going on? Oh, it's been going on 3 years. What documentation do you have in the file about the employee being late? Ooh, well, we don't have anything in the file. What have you got in the employee's annual performance evaluations about tardiness? Eesh, we never put it in that. Have you ever had any meetings with the employee where you've addressed it? I mean, it's been mentioned to him before. Did you document that? Did you document the counseling? Have you ever given them any discipline for it? Nah. Then I'm going to say, don't fire them for that until you've built your case up to where if you got asked about it in court, you could say, yeah, we did. He signed something when he came on board saying he'd be on time. He knows that being late is a grounds for discipline, including termination. We addressed it in the performance evaluation. It never got better. We gave him specific steps he needed to take. He didn't do anything about it, so we finally fired him because he was late all the time. Now, maybe this employee has been late for 3 years and we have terrible documentation of it. That's on us as an employer. Because if I go to court and that lawyer says to me, Mr. Tebow, you made this decision to fire the employee? I did. And your reason again was why? He was late all the time. Well, gosh, Mr. Tebow, when did this start? 3 years ago. Well, tell me all the times that you had counseling sessions with him about it. I mean, where did you give him a reprimand? Where did you tell him this wasn't acceptable? How did you communicate to him that this was not acceptable? I didn't. So it's important enough for you to fire him, but it's not important enough for you to sit down and tell this employee you're not following policy or procedure. And Mr. Tebow, here is his last 3 performance evaluations. Did you conduct those evaluations? I did. That's your signature at the bottom? It is. Show me in here where you have put in his performance evaluation that there's a problem with being late to work. It's not in there. What do you mean it's not in there, Mr. Tebow? You just fired him for not coming to work over a 3-year period, yet you documented in his file that he's done everything successfully. Maybe the reason is that I've tried to fire the guy because he was late all the time, but it undermines my credibility in the courtroom if I'm inconsistent with my practices. Okay? Say they call me and say, we have an opening for a nurse, county nurse manager in Butts County. We already know who we want to hire. The former county nurse manager retired after a long career. The person who's next in line, the junior person, would be great. They've been here 15 years. They'd be perfect for the job. They're going to be the most qualified. Do we still have to post this job? Yes, we have to post this job because we have written policies that say we post every single job opening we have. So do I think that your assistant county nurse manager is probably one who's going to get the job? Yeah. Is it fine if that's who you think you've identified as who you want? Yeah. But you can't skip the process that we've put into writing, because in another lawsuit, they might say to me, Mr. Tebow, you didn't, you posted this job opening, right? I did. And you have a policy that you're going to post job openings. That's right. But you don't always do that, do you? Well, I mean, sometimes, we already know who we're going to hire. We got the right person. So not always. So that makes me now look like I make up my own rules as I go. So much of your decision making in employment law has to do with consistency and documenting your reasons. I will tell them when we do interviews, save the notes. Who was the highest scoring candidate in the interviews? If we're not hiring the person who has the highest score, why not? If we go to court, can I defend this? Now, management should have a certain degree, in my opinion, of discretion. Part of management. We don't make hiring, firing, promotion on the computer, although maybe AI one day will make those decisions for us. I don't know. We're still humans. We need to be able to pick the person that we feel is the best qualified for the job. It's not always the person who scores the best on the interview. It might be somebody who scored a little lower, but who has better background experience. There are a myriad of reasons why we might come to a decision on employment. I just stress that we need to be very sound and solid in our methodology, in our decision-making process, and in our documentation of how we arrived at the decision. If we can do those every time, then I'm good with. I never tell them who to hire, who not to hire. I never tell them they can or can't fire somebody. I mean, that's up to them. My job is to tell them whether what they want to do is legal or not. And if it's legal, whether we got some problems with it, that I would feel better if we did some other stuff before you made that decision. That's my job. A couple of years ago, went through a reduction in force. This has been several years ago now, where they basically were taking a look at their workforce, and they were going to cut, I think there was a budget mandate or something. We're going to cut 10% of the workforce. And the question was, how do we do this legally? That was tough, okay, because we had to decide where we were cutting. And if we cut in this department and we let seniority be a main factor, but in this other department we cut and we made some exceptions, we did it based on something else, then that undermines our credibility for lawsuit purposes. I always think about it in terms of how can you defend this if you had to. And the main place I see people getting tripped up is when they make decisions that are inconsistent. They make decisions that are a result of inconsistent decision-making processes. they make one-off. Well, let's just cut the corner this time. Let's don't post that job this time. There's 100% chance we know who's going to get this job. When you start cutting corners and making exceptions, you might have a really good reason for doing it at the time, but when you get questioned about it later, under oath on a witness stand, it's easy for somebody to undermine that. Oh, yeah, I understand. You always follow the rules, except that one time when you didn't. You had a good reason for that. I'm sure you did. It just sets you up for being questioned later on. So that's sort of my informal sermon on HR practices and employment law practices. You have a quiz that is due Monday. And then next week, remember, we're not having class. So I need you to next week work on your career development assignment 3.2, your interviews, your resume, all that stuff. Please use your time wisely. I think that's due on April 20. Does anybody have it in front of them? April 21st? I think it's April 21st. That's coming. And you know what else happens at the end of the semester? April 21st. Final exams, all this other stuff y'all have going on. Please, please, please don't wait till the end to try to squeeze this in because you may not be able to do it. Week after next, when we come back to class, then we will finish up employment law. I'm kind of done lecturing, so that next week when we come back, I want to do a lot of discussion on employment law, and I'll give you the reading for it. I don't think I've assigned any cases this week. So in 2 weeks, it'll be mostly cases and articles and that kind of stuff. Don't go anywhere yet. Let me finish up roll on all the people who came.